contracts wisely, you need to understand whether or not you can get out of a contract that you have already signed. It could be that you signed a contract 5 years ago for a rolling service and their terms and conditions have changed. Well, it may be that you're not bound by the new terms and conditions. It could be that the way they're interpreting their contract is not the way you want to interpret their contract. That could be that it's ambiguous, or it could be that it doesn't actually accurately state exactly what their position is. I had this when I was flying back from Abu Dhabi and had some items stolen from my luggage by air handling staff. Now, the airline said that their terms said I mustn't leave valuables in my hold luggage, but that didn't mean they weren't responsible if one of their employees stole it. Now, there wasn't a happy ending to that interpretation because fighting someone in the Abu Dhabi courts was not actually one of those things I was prepared to do. But what if you've ended up with a contract that you read and you think, well, that is an outrageous term. It's one-sided. It's unacceptable. It might, for example, tie you into a 3-year rolling facilities management contract with automatic price increases. And unless you give notice on a particular day of the year, then it just rolls over for the next 3 years. Wow, that would be potentially ruinous. It's very one-sided. You can get out of contracts that you have signed either because they're interpreted differently or because of the Unfair Contract Terms Act 1977. Now, this is business to business, but it basically says that if you've got a really restrictive clause in the contract, it could be that it's an unfair contract term, and that would allow you to override it to say, although it's written in black and white, whether on a screen or on paper, it doesn't actually bind the parties. It's not legally enforceable. So even if you have signed a contract properly, it doesn't mean that all of the terms will necessarily be interpreted the way that one side suggests. So be careful. Make sure that you get advice if you've got a contract which has got a really nasty clause in, and you might think that it doesn't work, or you don't know that it actually works the way it's intended. The other thing to remember is that for every contract clause that's written, there may in fact be statutes or legislation which contradict those clauses or add to those clauses. So there could be some form of legislation that says that actually, for example, consumers have a right to cancel within 14 days. Some consumer contracts just don't make that clear. Wonder why that would be. Or it could be that, for example, it doesn't say anything about quality of goods or services for a construction contract. Those are set out by legislation. So on top of the words that are actually written into a contract, there's also nuance from implied terms, whether from cases. Under English law, we have a system of case precedents so that cases can set out general principles of law that apply to your project or your contract. And we also have statutes. They're set by government and they also can add to or change contracts. So contract interpretation is pretty much a skill. And just reading the bold words on the page doesn't necessarily give you all the answers. So next time you've got a contract with a clause that somebody's trying to enforce against you that, I don't know, doesn't look quite right or is making you worried, get some decent legal advice. Don't take it at face value. It might not be the whole of the story. But you should also make sure that you read your contracts carefully and any terms and conditions and updates so that you understand exactly what you're buying into and take any opportunity you can to negotiate them to better suit your business. Your contracts should safeguard your business, but they shouldn't be the end of the story. You can get advice that might help you to understand that contract better, that isn't just about the black and white terms.